Right, 10 o'clock, here we are. So thank you everyone for being here. We really appreciate the time and the interest in trainings. This is one of our first training kind of panel videos that we're going to produce. This one's called The Death of a Transaction, Defaults and Terminations. My name is Nicholas Peasley. I'm one of the staff attorneys at Oregon Realtors who had a hand in drafting the Oregon Realtors forms. And I work the legal hotline, so I'm the one that explains legal concepts to people throughout the day, which is why I'm going to be doing the training here on defaults and terminations. So we'll start it off, death of a transaction, that's what we're dealing with. For those of you that remember reading the book in high school, this is a parody of the Death of a Salesman book from Arthur Miller. So to begin with, we're gonna start at some very base descriptions of things. So a contract is something that is composed of obligations and promises. Generally, when you sign a contract, you are binding yourself to various obligations and promises. Those promises and obligations can be broad. For example, this one is taken from the Purchase and Sale Agreement, Form 1.1, the Oregon Realtors Purchase and Sale Agreement, and the obligation is that the buyer must provide reasonable notice to the seller of any inspections that are going to be taking place. Similarly, the seller has a very broad and non-detailed obligation of providing reasonable access for buyer's inspections. Those are both obligations. They're things that when you sign the contract, you're promising to do. Similarly, there are also some really narrow and very detailed obligations. This one is also taken from the Purchase and Sale Agreement, Section 41, specifically lines 266, and then I jump around throughout the lines. So you'll see the line numbering from the Residential Purchase and Sale Agreement that's on this, but you don't need to know the line numbering. I'll guide you through it. In this instance, when I talk about a narrow and detailed obligation, this is, for example, the representational obligation that the seller presents. They are they're promising that the following information is true, that they don't have any knowledge of undisclosed hazards as classified by federal or state law in or about the property, and that they've disclosed the presence of any hazardous substances they do know about, as well as various other information. And they also furthermore have an obligation to promptly notify the buyer if the seller gains actual knowledge that any of the information they make in the representations becomes false at some point throughout the transaction. So if you don't know about asbestos on the property at the start of the transaction, you followed your obligation. As soon as you learn about it, you have to make that disclosure to them. That's one of your obligations, the promise that's made by the seller to the buyer when they sign the contract. Obligations in contracts are what we call binding obligations. When a buyer and a seller sign a contract, they are guaranteeing and agreeing to each other that they will perform on all of the obligations and actions that are assigned to them. So in this previous slide, when the buyer says, I will provide reasonable notice to the seller, when you sign the contract, you are agreeing to perform that action that is assigned to you. When it says buyer must do X, you are supposed to do that. When a party fails to perform on one of their obligations, this is what we call a breach of contract. Now, when a contract has a breach of contract going on, the contract will tell you what you can do in those instances. Generally, if a party is in breach of the contract will say if a party can terminate or end the contract based on that breach. So you had a promise, the promise was not fulfilled. You broke your promise. Now the contract will tell you whether you can end the contract or if the other party can end the contract. Ending a contract, terminating, revoking, just ending it in general, it cuts off the requirement that you perform on your binding obligations. So when the buyer is supposed to provide reasonable notice before their inspections, that is only true while you are under contract. Once a contract has been ended, that obligation disappears. It's gone. If the contract does not, and this is for the Oregon Realtors Forum standard, if the contract does not allow a party to end the contract outright due to a breach, at that point, the Oregon Realtors forms have we have the parties declare what is called a default. So in the contract, it'll say, for example, that a party can, let's go back to this example, a buyer must provide reasonable notice to seller of any inspections that are taking place. It doesn't say anywhere in that section that the buyer can terminate if they do not provide reasonable notice. The seller can terminate if the buyer does not provide reasonable notice. There's no statement allowing them to terminate. And so in our contracts, the Oregon Realtors forms, we would say, in this instance, you're going to declare a default. So we're going to start with talking about defaults. These are forms 5.1 and 5.2 in the Oregon Realtors forms library. A default, broadly speaking, is a situation where someone has already failed. And so when we ask someone send a notice of default, we basically are saying, before you're going to say, hey, you broke your promises, you're in breach, you have to give them a notice and say, you broke something, please fix it. The notice of default is what allows a potentially defaulting party the chance to cure the issue. It's the chance to fix it, to put it back together. And so what you need to do is, if this is, as you can see in the images, if you broke the pot, you need to tell them, hey, you broke the pot, put it back together. and if they put it back together, that's the cure. I would have had other images of, there's a fun little Japanese process of like building broken pottery back together, but none of those are available in a really clean way on iStock Photos, and I didn't want to violate any copyrights by doing this training. So we're using a lot of stock photos to do these slides. Otherwise, I would have had some really precise imagery to show off exactly what I'm talking about here. But broadly speaking, when we talk about a default and a notice of default, it's the statement, hey, you broke this. And the default cure is putting that broken thing back together. Default forms. So on the Oregon Realtors Library, there are multiple forms that we have for default. A buyer and a seller both have different forms that they're going to be using for their defaults. So 5.1, this form up at the top here, this is the buyer's notice of default and opportunity to cure. It is used when the buyer is sending a seller a notice. The buyer is saying, hey seller, there was a thing you said you would do, you failed. By contrast, there's 5.2, the seller's notice of default and opportunity to cure. The seller sends this to the buyer when the buyer has done something wrong, and the seller says, hey buyer, you broke something, fix it. So the buyer and the seller have very distinct documents. The reasoning behind this is these documents go into pretty granular detail. And so when you have a buyer's notice of default, it has all of the buyer's specific invocations of default, whereas the seller's notice of default has seller-specific invocations of default. The seller should send the seller's notice of default if they are invoking a default of some sort, if they're claiming that the buyer has failed an obligation. The seller is not supposed to send the buyer's notice of default. In the instructions to use the form, we do tell you, this is for the buyer to do, or this is for the seller to use. If a seller sends a buyer's notice of default and opportunity to cure, it effectively has no actual usage, because all of the provisions in that buyer's notice of default are granting the seller a period of time to cure the thing. So if a seller wants to claim a default, the seller needs to send their own specific notice of default. In the default forms 5.1 and 5.2, there are various selections that you can choose of a default. So the forms will have specific descriptions of the defaults. The broker should select the exact default that applies to your scenario. We trawled the documents for as many instances of default as we could find that were clean and clear, and those have been described in the notice of default. When we say we've done there are a lot of defaults that exist in the contracts, and some of them are somewhat specific to very distinct forms, but in general, you're supposed to check the box for what you're dealing with. So if, for example, it's a seller's notice of default, they're pulling out a description of the buyer's default, they would check this box and say, buyer, you failed to provide earnest money by the earnest money deposit deadline. I'm checking that box. That's my reason for default that I'm invoking. The forms also have a fill-in-the-blank description of default at the base. This is section 6 in the seller's notice of default, and also section 6 in the buyer's notice of default. It essentially is additional provisions. It's the catch-all, where you can say buyer has failed their obligations under section blank, line such and such, in either the sales agreement or in one of the various addenda. You would then describe the specific acts or omissions that the buyer failed to perform. You would say, in this section of this general addendum that we added to the contract, you promised to do the following. You promised to mow the lawn while living there. You have not mowed the lawn. That is a breach of the exact line and section that we're talking about in this default. In this notice of default. And so what you want to do is stay as specific as possible about the defaults and grant the other party as many options and capacity, as much of the ability as they can to correct exactly the default that is invoked. The default selections, there are a fair number of them. If they are not perfectly applicable to what you're dealing with, you should write it in that additional section. Now, in general, if there is a default, if it's an obligation of a party, we found most of them and put them in the notices of default. So you should have checkboxes available to you for most of the instances that would come up as a possible default. If you have a party that says, I think the other party, it's a seller that says, I think the buyer did something wrong, you can give them the blank notice of default form and say, these are all obligations that are like pre-drafted into the contract. If the buyer has failed some of these, that is a default. So you can look this over and see, have they done everything they're supposed to do? If not, then we can send them a notice of default and say, please fix this, you're supposed to. The notices of default, this is for the buyer's notice to the seller. So this is form 5.1, buyer's notice of default. They have a cure period in them. When we talk about a cure period, this is that time frame where you can fix the pot. You can put the broken pottery back together. The way that this works in the buyer's notice to the seller is the buyer gives a notice of default to the seller, and they will give the seller a period of time to cure the thing. This is that first section right here on lines 10 and 11. Upon receiving this notice, for example, the seller has 3 business days, or if you need more than 3 business days, if you're giving them 10 business days to do whatever it is, you check the second box and write in 10 business days, or until closing, whichever is earlier. So if you have the checkbox on 3 business days and you're 2 days before closing, but you still want to send them that notice of default, you can. They get till closing to try and fix it, but they don't get beyond closing to fix this problem. They get this chance to cure the defaults that are described in the sections below. So this is the checkbox you would do with the additionals thing. You would say, hey, here's the thing you failed to do. Fix it. You promised to do this anyways. The seller can then cure this problem by fixing it, by doing whatever they were supposed to do, by providing the reasonable notice, by sending the letter they were supposed to send, whatever the fix ends up being based on the default you select, or by providing reasonable assurance that indicates that the seller is already in compliance with the obligation. The reason why this reasonable assurances usually exists is at times the buyer is wrong. The buyer says, seller, you are supposed to order the preliminary title report within 1 day after we had mutual acceptance. I haven't gotten the preliminary title report yet. So seller, you are in default and you need to sell me, you need to order that preliminary title report. The seller can fix it by just saying, hey, I already did. I ordered the preliminary title report the day after we signed the agreement. Here's a copy of the receipt that I got on that order from the title company. The reason why reasonable assurances exists is because at law, you get these occasional instances where a lawyer makes a silly argument where they say, you were supposed to fix it by ordering the title report. I sent you the default. You need to order another title report. That argument doesn't hold much water. And just to avoid that argument in general, we put in the ability for reasonable assurances to exist as well. It also lets parties kind of discuss and be reasonable about things. If the party, if the buyer says, I'm sorry, seller, I have to give you reasonable notice before the inspection can happen. I gave you 24 hours notice. I feel like that's reasonable. The seller can explain that it was an unreasonable amount of notice and they can make their argument. And if the parties agree, then that's great. You can talk about it. But generally, it gives you the chance to have more of a discussion point over what is a reasonable assurance. There's a question in the chat. If a buyer misses the earnest money deposit and wants to fix it themselves, and the seller literally hasn't even noticed, as a buyer's broker, what paperwork would you have the buyer sign and deliver to the seller? We will actually get somewhat in that direction. I can point it out to you when we get there. It's one of the examples I'm going to pull up, actually. So stay tuned. We'll get there. But the quick answer to your question at this stage is if the buyer misses the earnest money deposit and wants to fix it themselves, they deposit the earnest money. And if the seller has not terminated or invoked some kind of a default at that stage, you've already fixed it. So there's no additional step that you need to take to say like mea culpa, I already fixed it. If you fix the problem before a default is invoked, then there's no default that can be invoked. So secondly, we've also got the seller's notice to the default. In some instances, the seller is going to claim defaults that the buyer has an obligation. Buyer, you were supposed to do the following things. Please fix it. Please do those things. This is form 5.2 when the seller is invoking a default. This is also the same thing. You give them a cure period. Seller gives buyer 3 or if more days are required, blank business days or until closing, whichever is earlier, to fix the problem. Now, when the seller gives the buyer their notice of default, it's always the same number of business days, but this buyer has 3 ways that they can fix the default. The third one almost never happens, but it needs to exist for those fringe circumstances. The buyer can cure it either by fixing the thing, by sending the notice, by ordering the thing, by sending a letter to their lender that says, yes, I actually do intend to proceed with my loan. I told the seller I was going to get a conventional loan. Let's start this loan process, that sort of thing. You can also do it by providing a reasonable assurance. The buyer can provide reasonable assurances and say, yeah, no worries, I'm already in compliance. Or the buyer can waive or release a contingency that is being invoked by the seller as like an undergirding reason for the default. The example that's given here is the buyer fails to provide reasonable notice for inspection. The seller declares a default because the buyer is trying to get an inspection done without reasonable notice, and the buyer can release their rights in that inspection. So if, for example, the buyer goes up to the seller and says, okay, it's the 10th day of my diligence period. I have 8 hours left to do the inspection. Heads up, the inspector is going to show up in 2 hours. The seller can say that is super unreasonable. 2 hours notice before an inspector shows up to look at the house. This is crazy. This is not a reasonable amount of time. And the seller could at that stage put in a notice, declare a default, say notice a default. You did not give me reasonable notice before starting, having the inspector show up. At that point, the buyer can say, all right, fine, I'm out. I'm not doing the inspection anymore. I'm going to release my right to the inspection and that will fix the default. There's a question, so if they don't specifically invoke a default, they don't get to use it later if the party has fixed it, even if it was late. That is generally the case. Even if you were late on something and the party invokes a default later on in the transaction, imagine it this way for earnest money. This is the best example. So for earnest money deposit, section 25 of the purchase and sale agreement, within 3 business days, buyer will deliver earnest money to escrow or to the client account holder that's described in the transaction. They can terminate, correct. I'll get to that answer, Mike. So the idea behind the earnest money deposit, you have 3 days to deposit your earnest money. Please deliver the earnest money. Section 1 of the earnest money deposit section is seller can provide buyer with a Form 5.2 seller's notice of default, giving buyer the cure period to provide the earnest money deposit. So you can give them a notice of default and say, please send in the earnest money. Buyer fails to deliver the earnest money. This is our scenario. The buyer has failed to deliver the earnest money by the deadline. Seller sends in the notice of default, giving them 3 business days to deposit the earnest money for their cure period. And then they state, buyer failed to provide earnest money by the earnest money deposit deadline. You have 3 days to cure now, buyer. If the buyer provides the earnest money during that cure period, the transaction continues as though nothing is wrong. The default is fine. It's been fixed. It has been cured. If the buyer has already deposited the earnest money and you send a notice of default and say, buyer, you got to deposit the earnest money, they have already deposited the earnest money, so they have cured it upon delivery of that notice of default. And so if the buyer has already fixed the problem, at that stage, you no longer have that right to terminate. Now, Mickey asks, you can terminate, is that correct? For example, for the instance where the buyer fails to provide reasonable notice of inspection to the seller and the seller declares that a default, the seller says, buyer, you need to give me reasonable notice. There's no way you've gotten reasonable notice for this. It's 2 hours from now. If the buyer says, okay, I'm gonna give up my right to the inspection. I'm not taking the inspection anymore. It's not gonna happen. The seller can't then terminate because the buyer asked for an unreasonable inspection that they then waived before it happened. So the cure or the waiver does not entitle a party to termination. If the party has waived the thing that was going to cause a problem, if they have gotten rid of the obstruction, there is no termination right granted. Now, in the notice of, or the earnest money deposit, we in our forms do create a special situation where upon the failure of the earnest money deposit deadline, you have 2 options. You can either, as a seller, send the notice of default, or you can just terminate upon failure of the earnest money. So earnest money is not deposited. The seller can terminate for 2 days after the deadline of the earnest money deposit. If the buyer decides they want to fix it on their own and they try and fix it after that 2-day period, earnest money is still going back to the buyer. The buyer failed on their original deposit or earnest money deadline, and the seller can terminate. Earnest money will then be resent out to that buyer who delivered it late. But if the seller still wants to be under contract and the seller says, okay, buyer, I'm going to give you this notice of default. You've got 3 days to fix it, and the buyer fixes it within that 3-day period. At that stage, you don't have that right to terminate because of the failed default. So if in this one instance for earnest money, because it's the bifurcated answer where you can either default or terminate, if you do invoke the termination, you can terminate. If you go in the default direction, you give them the cure period. If they cure it, great, move on with your transaction. Generally, you're not going to give someone a notice of default unless you are trying to make the transaction still work. Yeah, so you are correct on that one, Nikki, because it's one of the parts of this section that I left out. Section lines 78 through, I believe, 81 describe the termination rights. 78 through 80 are the termination rights that come with the earnest money deposit failure. But if you're going the default direction, you give them a cure period, and if the thing is cured, you don't terminate based on that default. Whoops. So failure to cure default. So if a party fails to cure the default, you give them the 3-day period or the 5-day period, however many days you give them to fix this thing, you give them this cure period and they don't fix it. They fail nonetheless. The non-defaulting party then has the option to terminate the contract promptly. Now, as you can see on this lower part here, line 252 in the definitions section, we do define promptly in the Oregon Realtors contracts as soon as practicable, but no more than 2 business days. So when we say you should terminate the contract promptly, you have up to 2 business days to terminate after the party bricks their cure. So if you send in something, for example, a notice of default, they fail to cure or to provide any assurances by the time that cure period ends. So cure period, you give them 3 days. They do nothing during those 3 days. Now, at the end of that 3-day cure period, the party that has declared this default, they have a 2-day window to terminate the contract. If they terminate based on that 2-day window because a default was uncured, the earnest money goes back to the non-defaulting party. So if the seller says, buyer, you promised to do the following things, do them. I'm giving you extra time to do them, even by like more time than you were supposed to have under the contract. Cure the problem. And the buyer still doesn't cure the problem, seller keeps the earnest money. If the buyer puts in a notice of default and says, seller, you're supposed to do this thing, I'm going to give you 3 more days, and the seller doesn't do it, earnest money goes back to the buyer. As long as that buyer or seller invokes this termination within 2 days after their cure period ends. So they have a chance to do a thing up to a certain point. You invoke a default, you give them a couple days to fix. If they don't fix it at the end of that cure period, now you have 2 days to terminate. There is no requirement that the non-defaulting party terminate after a default goes uncured. So you get your 2 days, but you don't have to terminate if you don't want to. Why then send a default but not terminate? It's a prodding mechanism. You can, as a non-defaulting party, you can say, hey, other person, you were supposed to do this thing. If you don't do it, I will turn this car around. I will end this contract and keep the earnest money. And that usually is enough of a prod that someone goes, oh my goodness, I am so sorry, I forgot about that. And they will send the earnest money, or they will send the notice they were supposed to send, all kinds of stuff. If they don't do that thing, you can terminate, but you don't have to. If a party fails to terminate, if a non-defaulting party fails to terminate, you can send in another default. So for example, earnest money goes undelivered. You send them the notice of default. Time period ends. They have not deposited earnest money. At that point, you have a right to terminate and to garnish them after that earnest money, to go after the earnest money at small claims court. 2 days pass, you haven't terminated. That doesn't mean you can't send another default. At that point, you're 6-7 days into the transaction, and as the seller, you can say, okay, buyer, this time I'm really serious. I'm sending another notice of default, and at the end of this cure period you get on the second notice, I will terminate this time. And so you can continue sending notices of default. They are negotiative tools more often than not, but they are also something that once that default period and the cure period ends, you can terminate. It grants you a right for a period of time, a short window where you have a right that you wouldn't normally have under the contract, but it also allows everyone to be more reasonable in the transaction. So that's why defaults. With regards to ending a contract, question in the chat, is the termination language included in each default? Yes. So that's this section here. Failure to cure or provide written assurances within the cure period is a default under the sales agreement. After such a default, you may promptly give a notice of termination and retain the earnest money. There's a corollary in the buyer's notice of default that has the same kind of broad language but flipped. Instead of Form 5.4, it's Form 5.3, which is the buyer's notice of termination. But essentially, by sending a notice of default and it going uncured, you give yourself a chance to terminate, and that termination language is specifically outlined in every notice of default, as well as it's a checkbox in the notices of termination. We'll get to it though. So ending a contract, there are all kinds of ways to end a contract. We're going to talk about them. Specifically, there are 2 main ways in the Oregon Realtors forms that you can end a contract. The first is termination. Termination rights are, when you invoke a termination, it's the act of putting an end to all unperformed portions of a conditional contract. So all of the contractual promises and obligations, when you send in a termination, you terminate a contract, you are cutting those lines and you're saying, I no longer have to perform any of the things this contract says I have to do. Termination can be invoked in the Oregon Realtors forms in several instances. Those are, if the contract expressly says a buyer can terminate using a Form 5.3 notice of termination, at that point the buyer can terminate using that form. If the contract expressly says a seller can terminate using a Form 5.4 seller's notice of termination, at that point the seller can terminate using that form. If there is a notice of default that gets sent, the default was not cured, and a 2-day termination window has not closed, the non-defaulting party is able to terminate during that time frame. So it's a very conditional termination for default, but it'll make much more sense in practice because it's pretty consistent and pretty chronological with that process. Other times where you could terminate, if a party misrepresents a material fact related to the subject matter of the contract, you can just go straight to termination if you're the other party. You don't have to send them, even though the contract doesn't specifically have something in it that says, well, if the other party turns out to only be a partial owner of the property and the other owner of the property doesn't want to allow you to own the property, then you can terminate. We don't have that exact express language, but if there's a material fact of the contract that is breached or it's not true. If you're the opposite party, you can then terminate based on that material fact failing. The best instance to kind of explain that would be if a buyer it wants to purchase property and the seller says they own the property, but it turns out the seller only has a life estate. They're just living there because their uncle owns it and has been letting them live there. The seller can't sell that land. They don't own the fee simple right to sell that property. And so if you're the buyer and you suddenly learn, turns out seller doesn't own it, somebody else does, the seller just has a life estate per autre vie or something like that, at that point, the buyer can go straight to termination. They don't have to send a notice of default and say, oh, seller, you've got 3 days to gain fee simple ownership of this property. You can just go straight to termination because a material fact of this transaction has failed. And that material fact is the seller needs to actually own the land they're selling. Another instance where you can just go straight to termination is when a party wrongfully fails to close or cannot satisfy a condition to closing by the closing date. So if you get to closing and the buyer is supposed to provide $300,000 to purchase, they're supposed to show up with a briefcase full of money, and they show up with a briefcase that does not have any money in it, the seller can just terminate. They don't have to give them a default and say, okay, buyer, you got 3 more days, please cure this problem where you didn't bring enough money to closing. You can just go straight to termination. So all of these 5 instances are situations where you can just go straight to termination without having to worry about giving them an extra cure period. These are all of the instances where termination may be invoked. So that's one way to end a contract. The second way to end a contract is revocation. Revocation is only available to the buyer, and it is only available if the seller is required to deliver a seller's property disclosure statement. It entitles the buyer to an immediate return of all the deposits and any of the consideration that was delivered to escrow. So if you put like gold bars down, that's not technically a deposit. Or if you like put a lien on your house or on your car to pay for it in some way and the parties allowed that and escrow allowed it, those all get reversed when you revoke an offer. It creates a void contract under ORS 105-4755. It also allows escrow to disperse earnest money without matching escrow instructions. We'll cover that with much more depth. It is an important element of revocation that is kind of what makes it unique. So those are the 2 ways to end a contract. We're going to start by just talking about termination. In the Oregon Realtors Library, these are forms 5.3 and 5.4, and then there's a response that's forms 5.5 and 5.6. So giving notice of termination. Why? What does giving notice of termination do? In the Oregon Realtors Library, we have it established in the way that common law treats termination notice, which is by delivering notice of termination, you end the contract. What this means is you don't send a notice of termination unless you actually want it to end. The best practice is don't even say the words I terminate or my client wants to terminate in an email or on the phone unless you want to terminate. It's magic words. It's the open sesame language. When I say the words, the door opens. When I say I terminate the contract, my obligations are over and I terminate it. Maybe I've caused myself some legal problems if I did it wrong, but that doesn't mean I haven't terminated the contract. So the next question is, who gets a notice of termination? You deliver a copy of the notice of termination to the opposite party. If you're a buyer, you deliver a copy of the notice of termination to the seller. If you're a seller, you deliver your copy of a notice of termination to the buyer. You're also supposed to give a copy to escrow if you've got an escrow that's going. If it's a client trust account that's held by one of the brokers, then that's different. But generally, you should have an escrow that's dealing with this. The standard across the state is you'll have escrow. And in that case, give a copy of this form, this notice of termination to the escrow agent. It has the instructions on it. So the notice of termination language, this is drawn from the buyer's notice of termination, form 5.3. Notice of termination, section 4, lines 15 through 18. Buyer terminates sales agreement such and such, ABC 123, and all of the addenda thereto. This termination of the sales agreement and all of the addenda or amendments thereto becomes effective upon delivery of the signed notice of termination to the seller or the seller's agent. When you give the notice of termination to the seller or to the seller's agent, you've ended the contract. Seller and escrow agent are supposed to receive copies. This is why I always say give a copy to escrow if applicable. Escrow needs a matching separate escrow instruction from both parties under ORS 6965813. They have to have matching instructions or they can't disperse the money. And so we do tell you about that. Section 6 of the purchase and sale agreement, or the notice of default, says the escrow process, which is they aren't going to release the money unless they have matching instructions. So you need matching instructions. That's simply Oregon law written out into the contract. On your notice of termination, you will provide a reason for why you are terminating the contract. So the notice of termination will have a checkbox that has every single reason that is internal in the contracts for Oregon Realtors forms as for why you can terminate a contract. So for example, this lower box here, this section here, the forms will tell you where the earnest money is generally supposed to go, and we'll indicate that on this notice of termination as well. With that general kind of where the earnest money is supposed to go thing, that's based on the underlying purchase and sale agreement. For example, in the due diligence contingency, it has a section that reads, buyer has blank number of business days to complete all inspection surveys, tests, complete all negotiations, all that stuff, or to terminate the transaction by giving seller a Form 5.3 notice of termination, stating buyer's unconditional disapproval of the property during the due diligence period. If buyer terminates during this the transaction pursuant to this section, earnest money will be refunded to buyer. Now you'll note the language of this section here, this is directly mapped onto this. If the buyer is terminating, they're terminating because they unconditionally disapprove of the property during the due diligence period. And if they're terminating for this reason, earnest money is returned to the buyer. So you'll get a general idea in our notices of termination of exactly where money is supposed to move as long as something hasn't gone wrong. So that's the idea behind our notices of termination, is the language is pre-drafted and the guidance for escrow and earnest money is already somewhat pre-drafted as well. Now with that said, sometimes people are unreasonable and they do silly things. A buyer or seller can always send in a notice of termination for any reason at all. It's just not advised. In the contract, we literally say terminations under this section are not advised if you're terminating for some other reason. This would be a reason that's not stated in the contract. So if you're just making it up, you know, the seller hates the buyer, that's why I terminate. That is not a reason in the contract. And that's not a good reason to terminate the contract itself. So you might have to pay the price for that bad termination. In this instance, this is a seller's notice of termination. If the seller terminates and their reason is I hate the buyer, nothing in the contract lets you terminate because you hate the buyer. That's not a provision. So that would be an other termination. If the seller terminates for a reason that is unstated in the contract, there's a chance you're in breach of the sales agreement and you might lose your earnest money. You might give the buyer a claim to the earnest money. You might have additional money damages a buyer pursues, or you might have a specific performance lawsuit that goes on with that. So these other terminations, they exist if you've got like a custom general addendum that did something weird that we weren't expecting, but it's not really something that you should just use willy-nilly because you can. If you're doing a termination, use the pre-drafted language whenever possible because it's been vetted in the way that it moves, and it won't necessarily cause huge losses of earnest money or huge losses of to the buyer and the seller or the brokers because of specific performance lawsuits. Now, with that said, we put in a lot of advisory language to the clients that just because you can terminate, you really shouldn't necessarily terminate. So a seller acknowledges that they're also not relying on the representations of their agent about whether they're authorized to terminate. So if the seller says, I hate the buyer, I want to terminate, and you're like, okay, we can do that. The seller, by signing this notice of termination, is at least understanding and recognizing, because they've signed the document that says this, that you didn't tell them this is a great idea. Just handing them the form is not the same thing as saying, oh yeah, you can definitely terminate. You're going to make money on this. It's going to be great for you. If you're a broker that's telling your clients, yeah, you can terminate. It's going to be great for you. You're going to make money. Stop doing that. That's a bad thing. That's something brokers shouldn't be doing. So we provide advisory language in this in our contract. This, you'll note, is lines 12 through 15 on the seller's notice of termination. So I'm kind of jumping around on the notices, the termination documents themselves for the sake of the presentation. But in the documents themselves, all of these phrases are found at the line numbering that you'll see on this presentation. So if the seller is making a termination based on ill-advised reasons, they at least are recognizing that you did not tell them it's a great idea or a good move, and that they might be causing themselves some serious heartache if they do it wrong. When a party is terminated upon, this is part of the purchase and sale, the notice of termination. There's a section 5 in the buyer and the seller's notices of termination that talks about a response. You should get a response within 2 business days. If you are terminated in contract within a couple days after that termination, you should have a response on the buyer's response to termination or the seller's response to termination, whatever the corollary is to the notice of termination. If you're a seller sending a seller's notice of termination, buyer should respond on buyer's specific response form. If you're a buyer sending notice of termination, seller will respond on seller's response, which is buyer's is 5.5, seller's is 5.6. This response should happen within 2 business days. That's the amount of time that's kind of predicted in this the termination documents and the response documents. If you terminate and the other party doesn't respond within 2 days, more likely than not, you have a problem where one party just doesn't want to respond and they're being petulant. And if a party's being petulant and they're not responding, you're still stuck in that place where escrow can't send out the earnest money. So you need to start talking to your client about pursuing dispute resolution, because that's your only way to get earnest money out. The response determination for what the document does. A response determination is essentially just a recognition that termination happened and provision of escrow instructions. So if a buyer terminates the contract, the seller then says, oh, darn it, on this day I was terminated and the contract's over. Here are my escrow instructions. You want those escrow instructions from both parties, because if you don't, the money gets stuck in escrow. It gets stuck in escrow until either the parties agree or until a court orders that escrow disperse the money. So those two things have to happen before escrow can send the money out. And so if you have one party that sends a notice of termination and the other one doesn't send a response, escrow does not have matching identical instructions from both parties. So they, under Oregon law, cannot disperse earnest money. And so it's, as the visual indicates, it's trapped in a traffic jam of escrow at that point, and you're not getting your earnest money out for a while. The escrow instructions themselves look like this. So this is the notice of termination, form 5.4, the seller's notice of termination, which has the seller's instructions to escrow. This amount of money goes to this party. Here's the company, here's the officer, here's the number. Now this is the response to termination. This is the buyer's response. Now the buyer's instructions and the response to termination say the amount of money, the party, the company, officer, and number. You will note these are very similar. They are very similar because escrow needs them to be very similar, or escrow can't send the money out. So this is where it comes from. ORS 6965813, except as provided in a very distinct part of the statute. An escrow agent cannot close an escrow or disperse any funds or property in escrow without obtaining dated separate escrow instructions in writing from the principals in that transaction, the buyer and the seller, that is adequate to administer or close the transaction, or in the case of disbursement, to disperse the funds and the property. So when you give them these escrow instructions, you're telling them where that earnest money is supposed to go. That then allows them to say, great, I've followed my job under ORS 6965881, and I have instructions that provide me the right direction and kind of pathway for sending earnest money out to the parties. There are three types of escrow instruction outcomes. You have earnest money instructions that match, earnest money instructions that don't tessellate. I understand how poorly these images were chosen when I use the word matching. Can we get a copy of the presentation slides? Katie, if you people answer that one in chat, I think so. I don't see why not. But I am just the lawyer and not the education person. So with the idea of the escrow earnest money instructions, if the instructions match each other and they tessellate and escrow knows what they're doing, great. If the instructions don't work together, escrow can't send out the money. If the escrow instructions only come from one party and the other party is silent, escrow can't send out the money. So you can only get earnest money dispersal if the escrow instructions work with each other. If they don't work with each other, or they only have one-sided instructions, escrow's stuck. The way they get unstuck in those two frowny face situations is under ORS 6965818 and 9. Escrow cannot send out the earnest money unless they get separate escrow instructions that are matching, with one exception. The parties can agree to things after the fact. How nice. Escrow can disperse earnest money based on agreement of the parties executed after the initial sales agreement. So that means after your parties start arguing with each other, if they do come to an agreement, Mazel tov, earnest money gets sent out and everything's fine. On the other hand, the other way that escrow money gets sent out is with an order of a court, ORS 6965819. That order of the court is one where the court basically says, escrow, the buyer gets the money, and then the money goes to the buyer. This is why in all the dispute resolution provisions, we say to take it to small claims court or to arbitration and mediation if you can't agree on earnest money. That's because if the parties agree at mediation, you have a signed agreement between the parties. Great, escrow money can get sent out. If you go to arbitration, you get an arbitration order. If you go to small claims court and you get a small claims court judgment, you now have the order of a court of competent jurisdiction that can then back that up. Technically, with the arbitration order, you would have to go to court to have the court then say, this is a valid arbitration order. Okay, I back it up with a judicial order. And you'll get a court order, but having the arbitration order is the first step. That arbitration or small claims court allows you to get the earnest money under ORS 696-5819. An agreement at mediation, or just an agreement between the parties if they want to just be reasonable people, means that escrow can send the money out under ORS 696-5818A. And so those are the ways that you can kind of unstick your earnest money. Now, in the Oregon Realtors forms, specifically in the buyer's response to termination, Form 5.5, there is a special scenario. That special scenario is how we address specific performance. If the seller invokes termination and the contract does not permit the seller to do so, the buyer can choose to invoke specific performance. So if the seller says, I hate the buyer, that's why I want to terminate, the contract doesn't let you terminate because you hate the buyer, and the buyer can then go and pursue specific performance. The buyer's response to termination provides this information as well, lines 18 through 20 and then 21 through 25. If you believe the termination was invalid, you should immediately initiate dispute resolution proceedings and determining whether or not it was valid. You're not relying on your agent. So if the buyer is like, I don't think this is right, then we say, okay, go to dispute resolution. You can figure it out there. Also, if the buyer believes that the termination was invalid and they want to pursue specific performance, they should, 1, check the second box below. I'll get to those boxes. 2, they should instruct escrow to distribute earnest money, not to distribute earnest money. They should provide no instructions to escrow, and they should consult an attorney immediately about those remedies, because specific performance is absolutely a court order. In the response to termination as well, this is the checkboxes. So buyer can waive and release their rights to specific performance, at which point the seller and escrow can sell the property to a third party without fear that buyer will pursue a lawsuit. This is the first checkbox. By checking this box, we release and waive our rights, if any, to specific performance. Seller, put the house back on the market. Sell it to a third party with my blessing. Take it along. That's great. If the parties are amicable, you can check that box and move on. If the buyer doesn't want to allow that to happen, the buyer's like, no, I still think I'm entitled to this house. They should check the second box. By checking this, you're telling the seller, heads up, I'm coming after you. I might pursue a court order, like a specific performance lawsuit. I want a court order that says we did not terminate this contract. That's the two options that buyer has. This is special on the Form 5.5. This is not in the seller's response. Seller's response just says, I got terminated. Here are my escrow instructions. Buyer, because of this special right of specific performance they're entitled to, the buyer gets a special option in their response. Now, when we talk about specific performance, what are we talking about? Specific performance is where a court orders the parties to actually perform on their obligations. It's entitlement under ORS 72, 71, 60, specific right of specific performance, or replevin. You can get a judgment requiring specific performance for unique things, and property at law is considered truly unique. I think ORS 72, 71, 60 is actually just for personal property, but the same concept of specific performance applies to the real estate world as well. Technically, when we talk about specific performance, it is a right that is not available after termination. So when we talk about specific performance undoing a termination, what we want you to think is not that it like cancels the termination, but it rather intercepts and says, no, Your Honor, when they said they terminated, they didn't even know what they were talking about. That was not a termination. It's an argument that the contract was not terminated because the party that invoked that termination did not have the rights to do so, or they did not terminate in a manner that was allowed under the contract. So if a seller terminates because they hate the buyer can go to court and say, Your Honor, the contract doesn't let them terminate because they hate the buyer. And the court will say, you're right, it doesn't allow that. And they will undo that termination and say, no, you're going to pursue the exact contract you agreed to because you agreed to the terms. Now, if the parties don't pursue specific performance at law, what this means is in reality, it's been terminated. If you terminate and you do it for a bad reason and no one says, hey, that was a bad reason, the law won't upend the fact that no one's complaining about it. So someone has to go to court to undo that termination, which is why we talk about specific performance as a canceling mechanism of termination. But for your purposes, for understanding like the legality of it, you're not undoing termination. You're rather intercepting before the termination becomes valid and saying that didn't happen. Let's give an example of why we're so bullish about specific performance and why that checkbox exists. The worst case scenario of specific performance. Seller and original buyer. They want to sell a house to one another. There's a house, there was a contract, seller terminated it. Buyer goes to court and says, Your Honor, that termination was not valid. Seller, in the meantime, goes to their backup buyer and sells that house to the backup buyer with a different contract. Great, backup buyer now owns the contract, or owns the house. At that point, the judge has given a proper order. They say, you're right, buyer, original buyer, you were entitled to that original contract. Put it back together. And so the judge orders specific performance. At that point, the seller and the original buyer are now under the same original contract. That old contract is now not terminated anymore. And the seller owes this original buyer the original contract with the original house. You'll note the original house is down here with the backup buyer. It's not there with the original buyer. That's because the seller doesn't own it anymore. That's the problem. The seller is under contract to sell something they don't own, which means if the buyer finds a different house that meets their purposes, reasonably within their purposes, then the original buyer can pursue that, and the seller who bricked it with that old house that made these problems, that seller will in most cases have to pay the difference of the cost for this new comparable house for that original buyer. And so in a slow market where there are not many houses on the market and the buyer wants to buy a beautiful house with a view of the lake, the next time a beautiful house with a view of the lake within a reasonable time frame comes available, and that buyer says, well, it fits all my purposes, I want that beautiful house with the view of the lake, the seller pays the difference, which can be hundreds of thousands of dollars. It can be exceptionally expensive, and that seller is not pleased. And if you as a broker told them, don't worry about it, you can terminate this, it's no problem, let's start that backup offer going, your seller is going to sue you because they claimed you were supposed to know things better than they did. And in that case, this scenario, this worst case scenario, can be the end of a career for a broker. So if you got this checkbox here and there's no check on this first one, waiving and releasing specific performance, have a serious conversation with your buyer. Know exactly what's going on. You want to make absolutely certain that nothing goes wrong because it could be on your license and on your head if the worst case scenario does happen. Have a serious conversation with the buyer. Couldn't the original buyer ask for the original house? They can. So the original buyer can ask for the original house, but the seller doesn't own it anymore, and there's no obligation that the backup buyer sell it back to them. So what the buyer can do at that point then is ask that the seller purchase the original house from the backup buyers, buy it back a couple weeks after they just sold it, and that never happens. And there's no obligation at law that the backup buyer sell it. So you can ask for that. But the other thing courts do is they say, well, okay, given that you can't necessarily get that house back, the next comparable replacement we're going to take on, and that's fine. The only time where specific performance does not really cause huge problems for you is when you have, for example, like a manufactured home in a manufactured home planned park where all of the houses are identical almost exactly, and there's nothing about the purchase that the buyer was going for, or the original buyer wanted in that house, that was related to the specific location and view or uniqueness of that house. It's a fringe circumstance of law, but specific performance does not always get granted, or you don't always have to grant something special in that when there's another available house in that manufactured home park or that planned community that is literally identical. But don't take that to the bank, because it's like 1 out of 100 cases in the property law textbooks that actually involves that unique situation. So generally speaking, yes, you can ask for the original house, but you never get it back, which means the next comparable house is what that original buyer is going for. So that's termination and specific performance. The other thing we talked about termination, so this is the whole life of termination. The other thing is revocation. Revocation is rewinding the contract and undoing it, turning it back to where it never began. Revocation happens with Form 5.7, and it's a very unique situation that allows revocation. So let's start with the seller's property disclosure statement. Sometimes it's required. SPDS, this is the Seller's Property Disclosure Statement, SPDS. The SPDS is required in several instances under ORS 105.465. It has to be delivered by the seller when the buyer or the buyer's family is intending to use the property as a residence in any of the following situations. When the property is 1 to 4 dwelling units and the buyer or the buyer's family is living in it. When it's a condominium that's not subject to ORS 100.705, it's special rules about selling condominiums. It's a timeshare that's not subject to ORS 94.829. That's another special rule about selling timeshares. Or if it's a manufactured dwelling that is owned by the person who owns the land that the dwelling is situated on. So if you own the land and the manufactured home, and you're selling it to a buyer who wants to live in that manufactured home on the land that buyer is then going to own, SPDS is required. It's not required in some instances. These are the exclusions to the SPDS rules. The seller can invoke these exclusions and say, actually, I don't have to deliver the SPDS. They can, for instance, if it's the sale of a first sale of a dwelling that's never been occupied, the seller has a special statement under ORS 105.466. I want to say, I might not be exactly right on that number, where they can say, this is the first time this dwelling has ever been owned. it's unique, it's special. Here's the license, some special information about it. If you look at the statute, it's got exactly the statement that you need to provide. It's about a sentence and a half of information about it being a first sale of a dwelling never occupied. If you got that statement, you don't need to deliver the SPDS. If it's a sale by a financial institution, a bank, a credit union, that is acting as a custodian, agent, trustee, or by a foreclosure or a deed in lieu of foreclosure situation. So if they're the trustee or they're the body that's foreclosing on a house, they don't need to provide an SPDS. The bank doesn't know anything about the property. They're just foreclosing. If it's a sale by a court-appointed receiver, personal rep, trustee, conservator, or guardian, that's a situation where the seller does not need to give the SPDS. Now, I've bolded court-appointed because it's important. If you have a seller who is invoking the fact that they are a receiver, personal representative, trustee, conservator, or guardian, make sure they have a copy of the court order. It should exist. They should have a copy of it in their file somewhere. If they don't, they can contact the court and get one, but they need to have a court appointment. If you have a trust, for example, where all of the beneficiaries just agreed with each other that Cousin Ted is now going to be the trustee, that's not court appointed, which means Cousin Ted still has to provide the SPDS because he's not court appointed. Whoops, excuse me. If it's the sale by a government agency, that's the last situation, SPDS does not apply. So if BLA is selling the property, no court appointment, no need to provide the SPDS in that instance because it's a government agency. The SPDS, when it is required to be delivered, it gives the buyer a review period. If the SPDS is delivered, the buyer gets a right to revoke the offer for 5 business days after delivery of the SPDS. Now, technically at law, you get that 5-day period after delivery of the SPDS with nothing having to deal with the mutual acceptance of the contract. The contracts that you use in real estate, because the industry has basically requested it, all of the contracts that you have in real estate right now that have been drafted specifically for Oregon Realtors have modified this so that it is a 5-day revocation period after you both receive the SPDS and have mutual acceptance. So you get your 5-day period statutorily when you have received the SPDS, but once you have mutual acceptance and a SPDS in your hands, you get another 5-day period, or you get a 5-day period that begins at that point for your revocation. That's been built into the contracts, basically just to ensure that the practice is able to address these situations. But the actual revocation right at statute does not contemplate mutual acceptance at all. It's just once you've delivered it. So just know you get your 5-day revocation period after mutual acceptance and receipt of the SPDS. And that's 5 business days. If the seller fails or refuses to provide the SPDS, at that point, the buyer has a right of revocation that lasts until closing. So if the seller says, no, I don't think I need to do this, and they just refuse to send it, until closing, you can end that contract, you can revoke it. If the seller says, I don't have to deliver one because I am a trustee, but they're not a court-appointed trustee, well, the buyer can revoke until closing because the seller has failed to provide the SPDS. So make sure you provide it and make sure you know that you're accurately providing it if you are a seller or a seller's agent. What the revocation statement ends up being, this is under ORS 105.475. If the buyer revokes pursuant to a section, to this section, so the SPDS sections, the buyer is entitled to the immediate refund of all deposits and all other considerations delivered to any other party or escrow agent with respect to their offer, and the offer is void. Voiding at law means we've rewound it as though it never happened. It's not termination where the parties can discuss and say, I don't think that's true, or let's go after specific performance. I don't think this is valid. It's just done. You don't get a chance to fight a voided contract. It just doesn't exist. Furthermore, in Section 6, the deposits and considerations when they're returned to the buyer is supposed to sign a document that indemnifies and releases any liability for the escrow agent or the holder of this earnest money. So if for example, the buyer says, yeah, it's totally valid, I absolutely didn't get the SPDS, and they did. When they send that notice to the escrow agent, escrow doesn't necessarily have to check with the seller and make sure. And so if escrow does send the money out to the buyer because of a fraudulent SPDS revocation, at that point you've got a lawsuit as a seller suing the buyer over the earnest money, but it's not something that deals with the earnest money in that case. There's a question in chat: is the SPDS required for a commercial property that is an apartment complex 5 or more and not owner occupied? If it is 5 or more dwelling units, go back there we go. It does not apply. So the property has 1 to 4 dwelling units is when the SPDS applies. So 5, 6, 7 dwelling units, that's outside ORS 105.465. If a buyer is given SPDS before mutual acceptance, they still have 5 days from mutual acceptance to revoke as timeline. So at law, they get their 5 days from receiving the offer. In the contracts, they also get 5 days from mutual acceptance and delivery. So the way to think about it is even we have 2 separate schemes that are moving at the same time. Under your contract, the better way to think about it is SPDS revocation period is mutual acceptance and delivery of the SPDS. Once you have both of those, 5 days. Even if voided, do we need documents to, so another question, if the contract is voided, do we need to keep documentation of the contract for compliance? For your license, keep that documentation. At law, it's not a contract. For your documentation for OREA, keep the documentation. The seller of a manufactured home in a park have to do an SPDS. Seller in a manufactured home park does not have to do an SPDS unless they own the land underneath it. So if they're, and open question, if the seller is one of those like part shareholders where everyone, and it's like a collective ownership of the manufactured home park, and they own their manufactured home, but also have like a 30th share of the manufactured home park, they theoretically own both of those, which means they should provide an SPDS. So to clarify, if buyer is purchasing an investment property and then they do not have a right to the disclosures or a right to revoke under them, what if the disclosures are delivered anyways? So if the buyer is not intending to occupy the property as a residence, ORS 105.465 does not contemplate that as a situation where the SPDS has to be delivered. And that's just under Oregon law how it is. Now, if you deliver the disclosures anyways, the party can't necessarily terminate the contract or revoke the contract at that point under Oregon law, because the law only allows that revocation in instances where the SPDS was required. If we go back to the exact language of it, it must be pursuant to the section of the contract where they can revoke. So these are generally when they are entitled to get an SPDS, they can revoke. By contrast, if the party is never entitled to an SPDS, their revocation right arguably does not exist either, because they have never actually had a right to receive the SPDS. You just gave them a really uniquely written disclosure. Now, the contracts themselves do not create this granular of an understanding of it. So your contract will generally give them this right of termination after delivery of the SPDS, even though they didn't have to deliver it. So again, keep it in your mind, there's the legal side and the contractual side, what the contracts say. Because of the way that the standard of practice has been in the industry, and because essentially when Oregon Realtors drafted the forms, we didn't want to significantly disrupt the industry, we kept the industry standard for how we deal with SPDS rather than going strictly to the literal statutory language. So it's still, if you get the SPDS, after mutual acceptance, you have 5 days to revoke the contract. The buyer can waive their right to get this SPDS, and exclusions can be claimed. If neither has occurred, the buyer should receive it. So if the buyer says, I don't want it, or if there's been an exclusion that was claimed, great, buyer doesn't get it. Otherwise, buyer should get the SPDS. Form 5.7 allows the buyer to revoke their offer during that review period. It's the voiding the contract, and there's no requirement that the seller has to respond to the revocation. The buyer just sends the revocation to escrow. There's no, unlike termination where you've got notice and response, it's just revocation, and that's it. It just happens. Form 5.7 has a statement of revocation. Essentially, in this section, this is how you indicate to escrow what's going on with the like timelines of things. You would say, on this date, I received the SPDS, or it was never delivered. And then you would say, I want to revoke the contract because I disapprove within 5 days of when it was delivered, or they failed to deliver the thing, and I therefore am ending the contract. I disapprove of the SPDS prior to closing at any time, and it hasn't been delivered. The escrow instructions under Form 5.7 are also customized to this scenario, which basically say if you revoke pursuant to this rule, escrow can just immediately send the money back out to the parties that delivered it to them. If that happens, buyer is going to provide a copy of the statutory revocation of offer to escrow, and buyer is indemnifying escrow. They're saying, I guarantee that everything I'm telling you is accurate and true and correct. And if it's wrong, it's not escrow's fault. It's a lawsuit on that buyer for fraud at that point, essentially. So that's the escrow process on the SPDS. That's the end of the revocation period. At this point, that's the presentation, and I'll go into the questions themselves. So let's do the Q&A at this stage. So let's see. I see Jonathan said, so in this notice, notifying party unilaterally gives a cure period of their choosing, so long as it's no less than 3 days. That is correct. So in the notice of default, when you give a cure period, you're giving 3 or more days to fix the thing, and it's unilateral. So if a seller is delivering a notice of default, the seller chooses how many days they have to fix it. Now, if the seller wants to squeeze them and put the tightest timeline they can on it, they put 3 days. At that point, the buyer was supposed to do this thing 3 days ago anyways, so it's not like you're losing rights. You're granting an extra chance to the other party, and so you unilaterally get to choose how long that extra chance is. See, Roseanne had a question. So to clarify, if the buyer is purchasing an investment property, they do not have the right to the disclosures or a right to revoke them. What if the disclosure? Oh, we answered that one. In the SPDS, is the SPDS required for a commercial property? We answered that one. What are the time limits on the buyer's exposure to the amount of an earnest money deposit? What is the term called that limits the buyer's exposure to the amount of the earnest money deposit? The term that limits the buyer's exposure on earnest money deposit is liquid damages. So if a seller terminates the contract, or if for any reason the seller is entitled to the earnest money, in the purchase and sale agreements, there's a provision in there that explains earnest money is liquid damages. It's generally in the earnest money explanation. And in that case, this liquid damages provision says, seller, you're only entitled up to earnest money. That's the extent of the liability that the buyer has in this. The buyer, on the other hand, if the seller terminates for some reason, can pursue more than just the earnest money. I'm confused about the SPD exclusion. SPD says on lines 7 through 10 in section 1, section 1 will be completed if the seller is claiming exclusion, which contradicts what you've said about the seller with an exclusion not having to provide the SPD. So this is one of those things where ORS 105 was what the lawyers describe as poorly drafted. What that means is that the legislature provided the language of the SPDS to us, and they have required language that we have to put in the SPDS itself. Within that, the SPDS has this language of like the exclusion section, the not exclusion section. If you send an email to someone that says, hey, I am claiming a default of some sort, I think that, or not a default, exclusion. I am a seller, I'm court appointed, I'm claiming a court appointed exclusion. You just sent it by email. The other party doesn't have a right to argue that you didn't send, you still have to send an SPDS because you didn't fill it out on section 1. The law undergirds that just letting them know that you're invoking that exclusion works. Now, why does that exclusion exist at the top of the SPDS? Because it's a document for files, essentially. Most people fill out section 1 so that they have something they can point to in writing that proves that they have invoked an exclusion from the SPDS. Generally, from the legal side, it is advised that you still fill out section 1 even if you're claiming an exclusion, because section 1 is the claim of the exclusion. It's the same thing as providing written claims of the exclusion. It just is pre-drafted so you know it's accurate to how the legislature wanted it to be. So you don't have to fill out section 1 at law technically, but you really should just for your files, and it's the easiest way of addressing and kind of filling the requirements that you have. Do the new Oregon Realtors forms state all deadlines in number of business days? I believe ORF forms have deadlines in both business and calendar days. Yes-ish. So whenever possible, we shifted it over to business days. There are a few instances where it is calendar days. That is, for example, if you have a late offer that is like a counter offer on a late offer, you get 1 calendar day to respond. For a invocation of a contingent right to purchase, when the seller says, hey buyer, I got a better offer, you get 1 calendar day. And for lead-based paint, because it's a federal law standard, it's 10 calendar days. Otherwise, everything else that's less than 30 days is in business days. And for those like 30-day timeframes, we did it in calendar days because we don't want to have people deal with calculating 30 business days. So large timeframes, 90 days, that kind of thing, calendar. Shorter timeframes, 10 to 20 business days. Whenever we do describe a day in the contracts, we will tell you if it is business or calendar days. If a probate appoints an individual in a trust as a personal representative of the estate, do they need to provide the SPDS? If the probate court is the one that appointed them as a trustee or a personal representative of an estate, that is a court order in the jurisdiction of the probate court. So that is a court-appointed personal representative if you've got the order from the probate court. Let's see, what other questions do we have? Does the seller need an SPDS if the property is new construction? Technically, it depends is the best answer I can give you at this point. The SPDS needs to be delivered in large part when, I'll go back to the exact requirements on that one just to kind of undergird what I'm saying here. If it is a property with a dwelling unit that's designed to be built into it, or if the dwelling unit is completed, then yes. And a dwelling unit is generally defined as a place where you can sleep and a place where you can prepare food. So if there's electric and a roof over the head, yeah, you should probably have an SPDS even if it's a new construction. But we're getting into kind of a really broad zone of undefined areas, and I doubt that many people have actually had to think about that or wonder on that one, or like really ask the question, or fought back when a seller's like, I'm not providing the SPDS because the house is half finished. In general, it's a question of when it becomes a dwelling unit, and that's going to be in large part dependent on a couple things. In large part, I would also say it's probably your county and whether it has an occupancy permit that's issued. So, for example, if it's a non-occupied property that's like partly built, then, well, actually, now that I'm thinking about this, if it's still under construction, you would say it's a first sale, a dwelling never occupied, and that's your exclusion. So that's where you would say this is excluded because it's a first dwelling never occupied. If it's a heavy renovation where they've like knocked most of the building down and then put up another one, it's technically a new construction under Oregon law, and you would need an SPDS if there's still a dwelling structure in it and it's habitable. But that's getting into the weeds a little ways. So I apologize if I've confused you on that one, Kimberly. Otherwise, that's kind of the broad answer to it. Let's see. Are you recommending an addendum stating that any time periods are in business days, or to modify the ORF forms and lead-based paint? For areas where something is already in calendar days, like the lead-based paint stuff, you can, in our lead-based paint addendum, you can choose business days as a selection in there. That's allowed under the lead-based paint stuff. The difference there is that you have to opt into business days. So you can opt into business days on any of those calculations if you want to. It's just largely a basis of like how much you trust your calendar, whether you do business or calendar days. And then what are the condos not subject to ORS 100.705? There are some condominiums that are not going to be subject to that. That is generally, it's like a first sale of condominium is ORS 100.705. So a condominium that has been owned by several people is generally going to be subject to the SPDS, but consult ORS 100.705 if you are looking for like the granular explanations on condos. With that, that's the questions and that's the training. We also have an open house that's already going, and they've been going for about 6 minutes. So if you're interested in that, then feel free to hop over to our open house as well, or to register yourself for that. Thank you everyone for taking the time out of your day to do this training on forms, and we know that the death of a contract is not always the most interesting thing that you always get to learn about.